Hello and welcome to this webinar. My name's Helen Hogben and I'm a barrister specialising in discrimination, employment and education law. This webinar will focus on the legal obligations of schools towards children and young people with special educational needs and disabilities when considering whether to permanently exclude a pupil. It'll focus in particular on maintained schools and academies as opposed to any specific obligations of independent schools, a topic which is out with the scope of this talk. Now, around 1.6 million school pupils in England have special educational needs. And of that number, roughly 400,000 have an Education, Health and Care Plan, an EHC plan. One of the key changes introduced by the Children and Families Act 2014 was, according to the SEND Code of Practice, a greater focus on support that enables those with SEND to succeed in their education and make a successful transition to adulthood. Yet government statistics suggest that children and young people with an EHC plan are almost 4 times as likely to be permanently excluded from school than those who do not have special educational needs. And for those children with special educational needs but no EHC plan, the differential is even greater. They are 6 times more likely to be permanently excluded. Added to that, children with special educational needs have higher rates of absenteeism and persistent absenteeism from school, making it all the more difficult for them to access the curriculum. And a report published by Ofsted in June 2021 found that children with special educational needs were disproportionately affected by the pandemic and described the negative experiences of children and families, including missed and narrowed education, the absence of essential services such as physiotherapy or speech and language support, long waiting times for assessment and treatment, and a lack of joined-up commissioning and joint working across education, health and care. So let's look at the specific duties of schools when they're considering whether to permanently exclude a child or young person. The start point is the statutory guidance, that is, the suspension and permanent exclusion from maintained schools, academies and pupil referral units in England. That guidance makes it clear that the decision to permanently exclude a child is a measure of last resort and can only be made by the head teacher. Their powers to exclude are summarised in Part 3 of the guidance. The decision to exclude a pupil permanently should only be taken if, first, it is in response to a serious breach or persistent breaches of the school's behaviour policy, and second, where allowing the pupil to remain in school would seriously harm the education or welfare of the pupil themselves or others such as staff and other pupils in the school. Now, in my experience, schools often focus on the first stage of that test without giving adequate consideration to whether, notwithstanding any serious breach of behaviour, allowing the pupil to remain in school would seriously harm the education and welfare of others. The head teacher's decision to permanently exclude a pupil must be made in line with the principles of administrative law. In other words, it must be lawful with respect to the legislation relating directly to suspensions and permanent exclusions, and also a school's wider legal duties. And I'll come back to that in a moment when considering the school's duties under the Equality Act 2010. The decision must also be reasonable, it must be fair, and it must be proportionate. Witness evidence relating to incidents of poor behaviour should be taken in a way which is appropriate to the witness's age and understanding. And it's vitally important that before any decision to exclude is made, the views of the pupil affected by it must be taken into account, unless it would be inappropriate to do so. In addition to these duties, schools have a whole range of wider legal obligations, and one of those wider legal obligations is to make arrangements for safeguarding and to promote the welfare of pupils by having regard to guidance issued by the Secretary of State. That guidance includes working together to safeguard children, keeping children safe in education, often referred to as KICSI, behaviour in schools guidance, and so on. Furthermore, schools have legal obligations under the Equality Act in relation to children with disabilities. Section 85(2) of the Equality Act provides that the responsible body of a school must not discriminate against a pupil in the way it provides education for them, in the way it affords the pupil access to a benefit, facility or service, by not providing education for the pupil, by not affording the pupil access to a benefit, facility or service, by excluding the pupil from school, and by subjecting the pupil to any other detriment. And Section 85(6) also provides that schools are under a duty to make reasonable adjustments. Now, as we all know, discrimination can come in many forms, but in my experience, by far the most common claims that come before the first-tier tribunal, the SEND tribunal, are claims of a failure to make reasonable adjustments and discrimination arising from disability, which is a claim under Section 15 of the Equality Act 2010. More on those in a moment. But first, I'd like to talk briefly about disability. Section 6 of the Equality Act provides that a person has a disability if they have a physical or mental impairment, and that impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. The term substantial means more than minor or trivial, and long-term means that an impairment is likely to last for the rest of a person's life, or has lasted at least 12 months, or the total period for which it lasts is likely to be at least 12 months. If the person no longer has the condition, but it is likely to recur, then he or she will be considered to be a disabled person. In determining whether a condition has a substantial adverse effect, that must be assessed taking into account the effect of any medication that the person is taking, or any aids or assistance or adaptations that he or she uses, a wheelchair, walking stick, for example. And importantly, it's not the label that you attach to the physical or mental impairment that counts, it is the effect. A person who suffers from a mental impairment that means they struggle to keep regulated or to concentrate doesn't need a formal diagnosis of ADHD in order to satisfy the definition of disability. So when schools are exercising their powers to exclude a pupil with special educational needs, they must take into account the reality that a substantial number of children on the SEND register, whether diagnosed with a specific condition or not, are likely to satisfy the definition of disability under the Equality Act and therefore are protected from discrimination. Now, at the same time, when it comes to a serious or persistent breaches of a school's behaviour policy, which may often include incidents of violence, head teachers are often faced with a very difficult decision. They need to balance their obligations with regards to safeguarding and the welfare of all pupils and staff with their obligations towards children with special educational needs and disabilities. Excluded conditions. There are certain conditions which are not protected under the Equality Act 2010 as a disability, and those exceptions are contained within the Equality Act Disability Regulations 2010 and include, but are not limited to, a tendency to set fires, to steal, to physical or sexual abuse of others, exhibitionism and voyeurism. Now, at first glance, a child, say, with pathological demand avoidance, who can be prone to physical or violent outbursts when dysregulated, may seem to fall under these exclusions, in particular a tendency to physical abuse. However, following the decision of the upper tribunal in C&C and the governing body of a school from 2018, children in schools who, for example, have a tendency to physical abuse as a result of their impairment are in fact protected under the Equality Act. That case concerned a child with autism, anxiety and pathological demand avoidance who'd received a fixed-term exclusion for aggressive behaviour which resulted from his condition. The first-tier tribunal had originally dismissed his discrimination claim, relying on the exclusion from protection as a result of his tendency to physical abuse. But the upper tribunal said that that was wrong and that it violated his convention rights under Article 14. The upper tribunal held that the Secretary of State had failed to justify maintaining in force a provision which excluded from the ambit of protection of the Equality Act children whose behaviour in school was a manifestation of the very condition which called for special educational provision to be made for them. Accordingly, The upper tribunal concluded that in the context of education, Regulation 41C violates the Convention Rights of Children to Education where they have a recognised condition that is more likely to result in a tendency to physical abuse. It further concluded that whether Regulation 41C was read down under Section 3 of the Human Rights Act, or whether it was disapplied, the excluded child in this case did meet the definition of disability under the Equality Act 2010. Now, as I mentioned earlier, the most common claims of disability discrimination I see brought in the SEND Tribunal against schools are a failure to make reasonable adjustments and discrimination arising from disability. Let's take each of those in turn. First, the failure to make reasonable adjustments. Where a provision, criteria or practice applied by a school, for example, a policy relating to permanent exclusion or behaviour management, puts a disabled pupil at a substantial disadvantage, schools have a duty to take such steps as are reasonable to avoid that disadvantage. And the same duty applies to a disadvantage caused by the absence of an auxiliary aid or a service, for example, a wheelchair. The Equality Act 2010 doesn't define what's reasonable, but common factors will include the extent to which special educational provision will be provided to the disabled pupil, the resources of the school and the availability of financial or other assistance, the financial and other costs of making the adjustment, the extent to which taking any particular step would be effective in overcoming the substantial disadvantage suffered by a disabled pupil, the practicability of the adjustment, the effect of the disability on the individual, any health and safety requirements, the need to maintain academic, musical, sporting and other standards, and finally the interests of other pupils and prospective pupils. Under Section 66 of the Children and Families Act and Part 2 of the statutory guidance on suspensions and exclusion, the governing body of a school, when administering the exclusion process, must use their best endeavours to ensure that appropriate special educational provision is made for pupils with SEN and having regard to the SEND Code of Practice. Furthermore, paragraphs 56 and 57 of the statutory guidance on exclusions provide that where a school has concerns about the behaviour or risk of suspension and permanent exclusion of a pupil with SEN, a disability or an EHC plan, it should, in partnership with others, including where relevant the local authority, consider what additional support or alternative placement may be required. This should involve assessing the suitability of provision for a pupil's special educational needs or disability. And the guidance goes on at paragraph 57 to say that where a pupil has an EHC plan, schools should contact the local authority about any behavioural concerns at an early stage and consider requesting an early annual review prior to making the decision to suspend or permanently exclude. And for those with special educational needs but without an EHC plan, the school should review with external specialists as appropriate whether the current support arrangements are appropriate and what changes may be required. And this may provide a point for schools to request an educational health and care assessment or a review of the pupil's current package of support. Now, the steps taken by a school under these provisions are likely to be key in determining whether the school has acted in accordance with its duties to make reasonable adjustments. Discrimination arising from disability. Under Section 15 of the Equality Act, discrimination arising from disability arises in schools when a school subjects a student to unfavourable treatment because of something arising in consequence of his disability, and the school cannot prove that the unfavourable treatment was a proportionate means of achieving a legitimate aim. Now, on any analysis, permanent exclusion amounts to unfavourable treatment. If a child is permanently excluded from school for acting in a violent or disruptive way because, for example, he's dysregulated and can't control his actions, then this may well amount to something arising in consequence of his disability and is unlawful unless the school can prove that the permanent exclusion was a proportionate means of achieving a legitimate aim. In this context, examples of a legitimate aim might include the need to maintain behaviour standards or the need to ensure the welfare of pupils and staff. But even if the aim is legitimate, it must also be proportionate. And the more serious the disadvantage caused by the unfavourable treatment, the more compelling the justification for it must be. An exclusion is unlikely to be justified if the school has not complied with its duty to make reasonable adjustments. So if a child with SEND is permanently excluded from school, what happens next? Well, first, both the governing board and the local authority must make arrangements for the education of that pupil under Part 6 of the statutory guidance. Then, under Part 7, the governing board have a duty to review the head teacher's decision, irrespective of whether the parents of the affected pupil have challenged the decision or not. They must do that within 15 school days of receiving notice of the decision, if it's a permanent exclusion, and must arrange a meeting with the affected parties and make reasonable endeavours to hold that meeting within the same time frame. The parents of the affected pupil must be invited, as must the pupil himself or herself, if they're aged 18 or over. In all cases, the pupil should be made aware of their right to attend and to participate, and they should be enabled to make representations on their own behalf if they wish to do so. Having considered all of the evidence and representations, the governing board can either decline to reinstate the pupil or direct reinstatement of the pupil immediately or on a particular date. In reaching a decision on whether or not a pupil should be reinstated, the governing board should consider whether the decision to exclude was lawful, reasonable, and procedurally fair. This should take into account the welfare and safeguarding of the pupil and their peers, the head teacher's legal duties, and any evidence that was presented to the governing board in relation to the decision to exclude. If the governing board declines to reinstate the pupil, they must write to the parents and the head teacher, and where relevant, the local authority or, for example, the pupil's social worker. And they must set out the reasons for their decision in writing and without delay. They must also inform the pupil's parents of their right to ask for the decision to be reviewed by an independent review panel and the procedure for making that type of application. So for parents of a pupil with SEND who want to challenge the governing body's decision, there are two possible avenues. The first is to seek a review by the independent review panel. They have to do that within 15 school days from which they received written notice of the governing body's decision. And second, in the case of a child with a disability, to make a potential claim of disability discrimination under the Equality Act to the first tier tribunal, the SEND tribunal. Any such claim has to be made within 6 months of the date on which the discrimination is alleged to have taken place, so in the case of a permanent exclusion, within 6 months of that date. The independent review panel. If parents make an application within the time frame I've outlined, then the local authority, or in the case of an academy, the Academy Trust, must arrange for an IRP to review the decision of the governing board. Again, that review must begin within 15 school days of the day on which the parent's application was made, and it must be held at a reasonably accessible venue. The panel is typically made up of 3 members but can comprise 5, and must include representatives from each of the following categories. First, a lay member to chair the panel who's not worked in any school in a paid capacity. Second, current or former school governors who've served as a governor for at least 12 consecutive months in the last 5 years, provided they've not been teachers or head teachers during that time. And third, head teachers or individuals who've been a head teacher within the last 5 years. A clerk to the panel must also be appointed, and also a special educational needs expert if this is requested by the parents. The IRP has the following powers: either to uphold the governing board's decision not to reinstate, to recommend that the governing board considers reinstatement, or finally to quash the governing board's decision and direct that the governing board considers reinstatement. The panel can only quash a decision not to reinstate if it considers that that decision was flawed when considered in light of the principles applicable to an application for judicial review. The law on judicial review can be complicated, even for lawyers. However, the statutory guidance states clearly that independent review panels, who at the end of the day are lay members, are expected to understand the legislation and the legal principles that apply. The statutory guidance sets out those principles in the briefest of terms, and it sets out the tests that the IRP should apply when considering the governing board's decision in light of judicial review principles. Illegality. Did the governing board act outside the scope of its legal powers in deciding that the pupil should not be reinstated? Irrationality. Did the governing board rely on irrelevant points? Did they fail to take into account all relevant points? Or did they make a decision so unreasonable that no governing board acting reasonably in such circumstances could have made it? Procedural impropriety. Was the governing board's consideration so procedurally unfair or so flawed that justice was clearly not done? The statutory guidance points out that procedural impropriety means not simply a breach of some minor points of procedure, but something more substantive that has a significant impact on the quality of the decision-making process. And that will be a judgment for the panel to make. But the statutory guidance gives examples of the types of things that could give rise to procedural impropriety. Bias, failing to notify parents of their right to make representations, the governing board making a decision without having given parents an opportunity to make representations, failing to give reasons for a decision, or being a judge in your own cause. For example, if the head teacher who took the decision to permanently exclude was also given a vote on whether the pupil should then be reinstated. Now, it's important to note that the IRP has no power to order the reinstatement of the pupil. However, if they decide to quash the governing board's decision, they can direct them to reconsider reinstatement. In those circumstances, they may also order the local authority to adjust the school's budget, or in the case of an academy, the academy trust to make an equivalent payment to the local authority in whose area the school is located. Unless within 10 school days of receiving notice of the panel's decision, the governing board decides to reinstate the pupil, the sum of that payment is £4,000. Where the criteria for quashing a decision have not been met, the panel should consider whether it would be appropriate to recommend that a governing body reconsiders its decision not to reinstate the pupil. That shouldn't be the default position, but should be used where evidence or procedural flaws have been identified that don't meet the criteria for quashing the decision. It could include when new evidence presented at the review hearing was not available to the governing board at the time of its decision. Another avenue available to parents of children with SEND who believe that the decision to exclude their child was an act of disability discrimination is to lodge a claim in the first tier tribunal, the SEND tribunal. The SEND tribunal has jurisdiction to consider two types of cases. First, appeals against local authorities relating to special educational needs and education, health and care plans. And second, claims against schools relating to disability discrimination. As I've already outlined, any claim of disability discrimination must be received by the SEND tribunal within 6 months of the act of discrimination complained of, such as the decision to permanently exclude. The tribunal will seek to expedite the hearing of a claim involving permanent exclusion, and further details on how to make a claim and the relevant forms and procedure can be found on the government website now shown on the screen. That concludes this webinar on permanent exclusions and special educational needs. I do hope it's been of use, and thank you very much for listening.